Thank you, Madam Chair. Madam Chair, I'd ask that two articles by Jody Friedman and Richard Lazarus be included in the record. They provide a very clear and thorough explanation of the constitutionality of the EPA's Clean Power Rule. Thank you so much. We're at a big moment. Pope Francis is about to issue an encyclical on climate change. The College of Cardinals did a very dangerous thing. They named the Jesuit who taught chemistry as the Pope. Okay, so Pope Francis believes actually that science is the answer to our prayers, and we have to look at the smartest ways that we can deal with this to reduce the danger that growing greenhouse gases is going to pose to God's creation, the planet. And I think it's important for us then to find ways to accomplish that goal. So back in 1990, we worked on the Clean Air Act. I was on the committee that drafted and put that law on the books. And I added actually an energy efficiency section to the Clean Air Act to give more flexibility to the administrator at the EPA, George Bush's EPA administrator. And they were ways that utilities could comply with their acid rain requirements by undertaking activities beyond what was occurring at their power plants. And I can assure you that my intent and that of my congressional colleagues was to encourage utilities to look at the energy system in total to find ways of reducing sulfur pollution in the air. So, Ms. Heisling, one objection that has been raised about the Clean Power Plan is that utilities might have to go beyond the fence of their power plants to achieve their emission targets. In addition to the acid rain program that I just mentioned, are there other examples of using energy efficiency, renewables, or other beyond-the-fence activities under the Clean Air Act?
Yes. Very early on, something like 35 years ago, the EPA issued a rule that included washing of coal before it was burned as a compliance mechanism for dealing with the Clean Air Act. It was something that wasn't within this source. It wasn't a typical end-of-the-pipe kind of measure. In regulating interstate pollution or interstate conventional air pollutant under the Clean Air Act, EPA has for many years included renewables and energy efficiency as potential compliance mechanisms. If I may just extend this, the example a bit further afield, but I think it illustrates what you're talking about. If you look at the program under the Clean Air Act, under Section 202, to regulate mobile sources, you might, if you looked at that quickly, you might think that is the classic end-of-the-pipe measure. And yet, if you look at EPA's most recent rules on greenhouse gas emissions from mobile sources, EPA has, in the terms used today, I think gone beyond the fence line. They included flexibilities in their rules that made the rule, I think, a marvel of modern regulation. They included consideration of the footprint of the vehicle and the air conditioning refrigerants used in the vehicle and flex fuel vehicles. And so if you look not just at the pollution regulation that we've been talking about of stationary sources, but beyond that under the Clean Air Act, it's, I think, become standard.
I agree with you, and that was the intent of the 90 Act. It was to give more flexibility. It was to use a different model, and I think that's what this proposed rule is going to do as well. It's going to say to each state, you know, move in a way that accomplishes the goal, but, you know, we're going to be very flexible. So let me ask you this question. The constitutionality of EPA's approach to setting public health standards has been challenged before. The Supreme Court upheld EPA's approach in a 9-0 opinion in Whitman versus American Trucking in 2001. In 2011, the Supreme Court ruled that EPA has the authority to set standards for carbon pollution under Section 111D in an 8-0 opinion in American Electric Power versus Connecticut. And during the oral arguments in that case, the counsel argued on behalf of AEP, said to the court, "We believe that the EPA can consider, as it is undertaking to do, regulating existing non-modified sources under Section 111 of the Clean Air Act." Ms. Heisling, is there really any constitutional question about EPA's approach or their legal authority to regulate carbon pollution under Section 111 of the Clean Air Act?
No, I don't think so. I think the constitutional issues have been a distraction. I think they've been used to make people worry that maybe there is lurking a real constitutional issue, so we better interpret this statute narrowly, but the constitutional arguments, I think, are flimsy. And the statutory authority under the Clean Air Act, as I've said, I think is clear.
Okay, beautiful. Thank you. Thank you, Madam Chair.